Nashindwa kwani uko na radio cool leo.
Ulipa huyo. Ulipa huyo kutoa kitani. Lakini utaiba kila mtu bwana. Watu wazuri unaiba.
Senior counsel Martha Karua is coming.
Excellent.
She'll be the one leading us as a senior counsel.
Thank you.
Senior counsel Karonzo Musyoka will also be
Around?
Will be around, but he's attending his father's funeral.
Okay.
We expect Wakili Eugene Wamalwa.
Yes.
Albert Simiu.
Yes.
Kibe Mungai.
Yes.
And others.
Thank you.
So we have a battery of lawyers to tackle the DPP, and we are equal to the task.
Thank you, sir.
So,
I think we can consult a bit.
yeah, we can consult a bit.
The other lawyers are coming. We are some.
Here with you.
yes, yes.
Toa mwili.
Akisimalize gari. Kwa shoti yangu.
Wewe
Panga alafu ukae hapo.
Waulize tukipanga.
Naomba.
Anavuta. Zikikatika atafanya.
Number E024 of 2025, Republic versus George Natembeya.
Your Honor.
A minute.
Walubengo, Waningilo.
The last name?
Walubengo, Waningilo. Your Honor, we just been served the charge sheet now. They just get on record.
Lombardi, you have not commented about the second.
Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
It's not true.
The payment made by public government of Trans Nzoia to Lima Agro Science Limited, Myra Stores and Easterly Wheels Limited in conflict of your public.
Mr. Jerry.
No, Your Honor, I petition to purport to quote the direction sections.
We believe that because we oppose bail, and bail being ordinarily a right, then it has to go first in an application to oppose bail. Then we take the court through their affidavit, the functional matrix. Then we take the court through their affidavit, the functional matrix. Allow me to take the court through the legal matrix. And I'll start by indicating that the law on bail is almost Article 50, there, sections, and that every arrested person or an accused person has entitlement to bail. I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give,
I promise they will say what I'm telling you.
if you can give them a chance,
The council,
if you can give them a chance,
the council to deliver,
give them a chance.
the council to deliver, just speak for the state which it represents.
A minute.
So to deliver, just speak for the state which it
A minute.
represents.
A minute.
Speak for the state which it
A minute.
represents.
A minute.
The accused has sufficient
A
defense.
minute. Decorum.
Accused has sufficient
A
defense.
minute. Decorum. I repeat. Decorum. I repeat. For the third time. Decorum. It is by law.
It is strike law that the denial of bail where there are compelling reasons is not a breach of the presumption of innocence. Then I trust the court to have a look at Chomli case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice the Tom Chomli case is clear on the relationship between the right to bail
I
and...
got to.
Sorry?
And the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right to presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. You know, the net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of a right under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided bail and bond policy guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. You know, in concluding on the legal issues, the primary purpose of bond is to ensure that an even where it is shown that an accused person shall turn up for trial, even where it is shown that an accused person shall turn up for trial, if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. Where releasing an accused person on bail, even when it is shown that they will attend trial, where releasing them on bail will prejudice the trial and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. And Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on Section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akula.
And on your file an affidavit sworn on 19th May 2025 by Mr. Robert Swan. 19th of May 2025, this morning. Sorry, yesterday, Ronald.
That is where I got started.
Yes, 19.
19.
You filed this morning.
5.
Yes, sir. It is sworn by Robert Bono.
Sworn by?
Robert Bono. The EACC forensic examiner. There are the factual reasons or grounds to reject bail agreed upon from paragraph 1 to paragraph 12. However, I will cluster them into
Paragraphs
three,
1
to paragraph 12. And however, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their mandate. This has been reported and is captured under annexure number R38 at Kitale Police Station. R38, PR38, annexure PR38. Your Honor, we have a next photographs of security
of the Evidence Act.
That is your name?
Willis Otieno, counsel for the first accused. Section 106.
Yes.
Section 106B
On electronic evidence.
on electronic evidence.
You get your time.
No, I want to refer to it.
You get your time. Let it continue.
Also, we have a next affidavit.